Thank you, Mr. Moore, for your highly interesting keynote speech, which provided an excellent overview of both the challenges that the commercial arbitration faces today and also the new policies that the ICC Court has implemented over the past couple of years. It was really interesting to hear. I'm much obliged to have been given the privilege to submit some comments in response to Mr. Moore's keynote. And in so doing, I have decided to discuss briefly what some of those new ICC policies might mean from the viewpoint of the Finland Arbitration Institute. As an introduction, I should remind the audience that when we drafted our current FAI arbitration rules, which came into force in 2013, the ICC rules served as our model in many respects. And this is especially true for multi-contract and multi-party provisions, which are contained in Articles 10 to 14 of our FAI rules. For example, our provisions on joinder of additional parties and consolidation of different arbitrations are heavily influenced by the respective provisions of the ICC rules, which govern these issues. The reason why our Rules Revision Task Force wanted to seek inspiration, particularly from the ICC rules, was the fact that the ICC rules do represent by far the most well-known set of institutional arbitration rules, which contain specific regulations on multi-contract and multi-party arbitration. And we thought that adopting similar provisions in the FAI rules would make it easier to explain, both to Finnish and foreign users of FAI arbitration, how these novel provisions were meant to be applied in practice. And now that the FAI rules have been in force for many years already, I think it's safe to say that they have worked rather well in practice. But in light of the amendments that the ICC has recently made, both to its own rules and also to its guidance note, it is appropriate to contemplate whether the FAI should also follow suit, at least on certain points. As you heard from Mr. Moore's speech, there are many innovations that the ICC has implemented or put into effect lately. Some of the most important ones include the launch of expedited rules for small value claims, the increase of transparency, in particular through the reasoning of the court's decisions, the emphasis put on the ethics in arbitration, for example, through guidance note on disclosure, the increase in efficiency, for instance, by introducing specific sanctions for delays, and finally, which Mr. Moore didn't mention, but I find it important as well, certain additional services, such as the ICC's role in the administration of so-called sealed offers. And in my following presentation, I will very briefly touch upon these issues from the viewpoint of the Finland Arbitration Institute. As for fast-track arbitration, I should mention that the Finland Arbitration Institute has had a separate set of rules for expedited cases already since 2004. Those rules were also amended in connection with our rules revision process 4 years ago. Interestingly, however, the number of expedited arbitrations in Finland has remained quite modest compared to the number of standard FAI arbitrations. If we look at the statistics, they show that between the years 2004 and 2016, the FAI received in total 757 requests for arbitration. And out of these, only 48 were expedited cases. So in other words, a mere 6% of all arbitrations over the past 13 years were governed by the expedited rules. And one may ask, what is the reason for this rather meager uptake of expedited arbitration in Finland? While there is no obvious explanation, I believe it may have something to do with the fact that disputes are resolved in Finland very efficiently also under our standard FAI rules, where the median duration of arbitration proceedings has been consistently quite short, less than 9 months. There may also be specific cultural issues involved. To me, it looks as if the parties, and especially the Finnish ones, are rarely willing to give up on their right to have a reasoned award or even to dispense with the oral hearing. But still, the fact remains that these expedited rules may provide a viable alternative to our standard FAI rules in low-value cases where the legal and factual circumstances of the dispute are rather straightforward. Moving on to the issue of transparency, I think the ICC Court has made a truly groundbreaking move when starting to give reasons for its decisions upon any party's request. As we heard, not only in cases of challenge and replacement of arbitrators, but also with respect to decisions on prima facie jurisdiction and consolidation of arbitrations. It's difficult to disagree that parties to any arbitral proceedings will have a legitimate right to request reasons, even for such administrative rulings. And I believe that other arbitral institutions should follow in the ICC's footsteps here. That said, as far as the FAI is concerned, I have to admit that our limited resources do pose certain obstacles in this regard, since providing reasons for various administrative decisions would require quite a lot of time and effort of the FAI board and secretariat. So as things currently stand, I'm afraid that we are not in a position to give detailed reasons for all of our decisions at this stage. However, I should mention that we have already now done so in a few cases, for example, concerning objections to confirmation of arbitrators, where the FAI board considered that communicating the reasons for its decision was particularly important to the parties. And this is something we definitely intend to do also going forward on a case-by-case basis. Then a few words about the ICC's efforts to promote ethics in arbitration, and especially as to issues of disclosure. I would simply like to note and remind you that also the FAI arbitrators' guidelines, which you will find on our website, contain specific recommendations on this topic, which are not that different from the provisions that the ICC has now adopted in its guidance notes. And as many of you probably recall, the FAI emphasizes that in determining whether to disclose a given circumstance, a prospective arbitrator candidate is encouraged to seek inspiration and guidance from the various lists of the IBA guidelines on conflicts of interest. And we also recommend that any doubt as to whether a certain circumstance should be disclosed or not should be resolved in favor of disclosure, along the lines that is recommended also in the IBA guidelines. If we then turn to the question of efficiency, this was one of the key areas also in connection with the FAI rules revision process. Our rules contain many provisions which explicitly aim at increasing the efficiency of arbitration, most notably Article 25(3), according to which all participants in the arbitration shall act in good faith and make every effort to contribute to the efficient conduct of the proceedings, in order to avoid unnecessary costs and delays. This implies that a party's failure to comply with its procedural duties under Article 25 may result in the arbitral tribunal issuing a negative cost decision on a non-compliant party. And equally important, if the FAI finds that the arbitral tribunal has failed to contribute to the efficient conduct of the proceedings, the FAI board may penalize or sanction the tribunal that has acted in a blameworthy manner at the end of the proceedings by reducing the tribunal's fees. However, we do not currently have a system such as the one that is adopted in the ICC guidance note, where the arbitrator's fees may be reduced by a certain percentage amount, fixed percentage amount, if the tribunal submits its draft award for scrutiny later than expected and without a justified reason. While some may consider that this ICC model is a bit mechanistic, I personally find it well thought out. And I think that it might be beneficial also for other arbitral institutions to introduce more formal rules on how the arbitrator's delay in issuing the award will affect the fee determination. To me, this would promote both transparency and predictability in the fixing of the arbitrator's fees. And this is why it should be given close thought also at the Finland Arbitration Institute. Then finally, as regards the ICC's additional services, I'm sorry to say that we do not have a procedure whereby the FAI could administer sealed offers in the way that the ICC has now started to do. And in my opinion, this is a really interesting innovation, which will not only promote amicable settlements of disputes, but in the best case scenario also reduce the overall cost of arbitration. and also serve to, or give the parties and the arbitral tribunals a valuable tool to increase the quality of court decisions in ICC arbitrations. So kudos to the ICC court for a great innovation, which other institutes should also carefully consider. That was pretty much all I wanted to say in response to Alex's excellent keynote. And without further ado, I will now give the floor to Ms. Inka Hanefeld and Ms. Maria Hauser-Morell for their interview and discussion on the topic of how does the ICC arbitral process work in practice. Thank you very much.